The WILLS ACT 1971 Act 360. Section 1. Power to make a will. 1. Any person of or above the age of 18 years may make a will in writing and in accordance with this act, make a will disposing of any property which is his or to which he will be entitled at the time of his death or to which he may be entitled thereafter. 2. No person suffering from insanity or infirmity of mind so as to be incapable of understanding the nature or effect of a will shall have capacity to make a will during the continuance of that insanity or infirmity of mind. 3. A will, or any provision of a will, obtained by fraud or made under duress or undue influence, shall be void. Section 2. Execution of a will. 2. 1. No will shall be valid unless it is in writing and signed by the testator or by some other person at his direction. 2. No signature shall be operative to give effect to any disposition or direction which is underneath or which follows it, or which is inserted after the signature has been made. 3. The signature of the testator shall be made or acknowledged by him in the presence of 2 or more witnesses present at the same time. 4. A signature by some other person in the direction of the testator shall be made by that other person in the presence of the testator and 2 or more witnesses present at the same time. 5. The witnesses shall attest and sign the will in the presence of the testator, but no form of attestation shall be necessary. 6. Where the testator is blind or illiterate, a competent person shall carefully read over and explain to him the contents of the will before it is executed, and shall declare in writing upon the will that he had so read over and explained its contents to the testator, and that the testator appeared perfectly to understand it before it was executed. Section 3. Executors and witnesses. 3. 1. Any person of or above the age of 21 years and having the capacity to enter into a contract may be appointed an executor of a will. 2. Any person appointed by will to be an executor may attest that will. 3. A creditor of the testator may be an attesting witness, notwithstanding that by the will the property of the testator is charged with the payment of debts. 4. Any beneficial disposition of or affecting any property other than charges or directions for the payment of any debt given by a will to a person who attests the execution of that will shall be void unless the will is duly executed without his attestation and without that of any other such person. Section 4. Incorporation of other documents. 4. 1. A will may not incorporate another document unless that document was in existence at the time the will was executed and is sufficiently identified in the will. 2. Oral evidence shall be admissible for the purpose of identification. Documents. Section 5. Alteration of a will. 5. 1. No alteration made in a will shall have effect unless it is separately executed in the same manner as is required for the execution of the will, or unless it has been made valid by the re-execution of the will or by the subsequent execution of some codicil thereto. 2. Notwithstanding Section 2, a separate execution of an alteration shall be deemed sufficient if it is apparent on the face of the will that the testator intended to give effect by such execution to the alteration. Section 6. Armed Forces Wills. 6. 1. Notwithstanding any provision of this act to the contrary, any member of the armed forces of whatever age may, while engaged on active service, make a will in any of the following forms. A. Written and unattested, if the material provisions and signature are in the handwriting of the testator. B. Written, whether or not in the handwriting of the testator, and attested by 1 witness. C. Orally before 2 witnesses. 2. Any beneficial disposition of or affecting any property, other than charges or directions for the payment of any debt given by a will made under this section to a witness to that will shall be void unless the will is duly executed, if written, or witnessed, if oral, without his attestation and without that of any other such person. 3. A will made in accordance with this section shall remain valid even though the testator ceases to be a member of the armed forces. 4. A will made in accordance with this section may be revoked by another will made in accordance with this section or by any of the means of revocation provided in Section 9. 5. A will made in accordance with this section may revoke. An earlier will made by the testator in accordance with Section 2. Section 7. Rules of construction. 7. 1. A will shall take effect as if it had been executed immediately, before the death of the testator, unless a contrary intention appears. From the will. 2. A disposition of immovable property without any words. Of limitation shall pass the whole of the estate or interest therein, which the testator has power to dispose of by will. 3. A general disposition of the land of a testator or of his, land at any place, or in the occupation of any person or otherwise, described in a general manner, shall include lands of whatsoever, estate or tenure, unless a contrary intention appears from the will. 4. A general disposition of the movable or immovable property of a testator shall include any property to which he may have power to appoint in any manner he may think fit. 5. A general or residuary disposition shall operate to confer a power to exercise a power of appointment, unless a contrary intention appears from the will. 6. A residuary disposition shall include property comprised in lapsed and void dispositions, unless a contrary intention appears from the will. 7. Where a testator and a beneficiary under his will die in circumstances A. in which it appears that their deaths were simultaneous, or B. rendering it uncertain which of them survived the other, the beneficiary shall be deemed to have survived the testator for all purposes affecting the entitlement to property under the will of that testator, but for the purposes of the entitlement of such testator to that property under any will of the aforementioned beneficiary. That beneficiary shall be deemed to have survived the aforementioned testator, unless a contrary intention appears from the will. Section 8. Lapsed dispositions. 8. 1. A disposition made to a person who predeceases the testator, or which is contrary to law or otherwise incapable of taking effect, shall lapse and fall into residue, unless a contrary intention appears from the will. 2. Notwithstanding subsection 1. A disposition made by A. testator to his descendant, other than for an estate determinable, at or before the death of that descendant, shall not lapse where that descendant predeceases a testator leaving issue surviving the testator, but shall take effect as a disposition to such issue postapes, unless a contrary intention appears from the will. Section 9. Revocation of a will. 9. 1. A will may be revoked by tearing or other physical destruction by the testator or by some other person in his presence, and by his direction with the intention of revoking it. 2. A will may be revoked by a written declaration of intention to revoke, executed in the same manner as a will. 3. A will may be revoked by the execution of another will, which is expressed to revoke the previous will. 4. A will which is not expressed to revoke a previous will shall not be deemed to have revoked that previous will except to the extent that it is inconsistent with the previous will. 5. Where a testator destroys a will. A. As a result of fraud or undue influence, or B. under mistake of fact or law, intending to make some other disposition of his property which is not validly made. Such destruction shall not be deemed to have revoked the will. Section 10. Revival of a revoked will. 10. 1. No will or any part of a will which is in any manner revoked shall be revived otherwise than by its re-execution, or by a written declaration of intention to revive it, executed in the same manner as a will. 2. Whenever a will which is partly revoked and afterwards wholly revoked is revived, the revival shall extend to the whole will. Section 11. Custody of wills. 11. Any person may, in his lifetime, deposit for safe custody in the High Court his own will, sealed up under his own seal in the seal of the court. Section 12. Deposit of wills found after death of testator. 12. 1. Any person who has in his possession or under his control any paper or writing of any deceased person, being or purporting to be testamentary, shall immediately deposit it with the High Court or any other court. 2. If the court with which any such paper or writing is deposited is not the High Court, it shall forthwith cause it to be transmitted to the High Court. 3. Any person who fails to deposit any such paper or writing, as required by subsection 1 of this section, within 14 days after having knowledge of the death of the deceased, shall be guilty of an offense and liable on conviction to a fine not exceeding 10,000 sades or to imprisonment not exceeding 10 years or to both. Section 13. Provision for dependents. 13. 1. If, upon application being made, not later than 3 years from the date upon which probate of the will is granted, the High Court is of the opinion that a testator has not made reason, able provision, whether during his lifetime or by his will, for the maintenance of any father, mother, spouse, or child under 18 years of age of the testator, and that hardship will thereby be caused. The High Court may, taking account of all relevant circumstances, notwithstanding the provisions of the will, make reasonable provision for the needs of such father, mother, spouse, or child out of the estate of the deceased. 2. Without prejudice to the generality of subsection 1. Such reasonable provision may include a. Payment of a lump sum, whether immediate or deferred, or grant an annuity or series of payments. b. Grant of an estate or interest in immovable property for life or any lesser period. Will includes a codicil and any other testamentary instrument, and testator shall be construed accordingly.